and ISDS rules, among others. And she has represented clients in U.S. litigation with international ramifications before the United States Supreme Court and various courts of appeals. Marine's representations include various matters. Importantly, at least for those that are in Latin America and Colombia, she recently won an award on behalf of Colombia in an electricity-related matters, and of course, the folks of that country are ecstatic about that and many other wins. Most importantly, Marine is one of our esteemed advisory committee members at WOW, and she has been incredibly supportive, both with her ideas and initiatives. So I would like to give a big thank to Marine. And now going to the panel, I would like to say that investor-state arbitration and ISDS is of course a very hot topic, and we're seeing the evolution that has started for many years now. One of the topics that is in everyone's mind is whether it will be an appeals court, an appeals mechanism, or whether it will be a court. And this is part of the subject matter today. So I hope that you're very attentive. I hope that you pay a lot of attention, because this is an incredible panel, and I'm lucky to be just announcing it. So with that, Marine, the floor is totally yours.
Thank you so much, Jose Antonio, for the lovely introduction. And welcome everyone to what I think is going to be a really interesting discussion on what is indeed the hot topic of the day in international arbitration, and that is concrete proposals for reform of the investor-state dispute settlement system. You know, the UNCTAD databases tell us that we have something like 2,600 international investment agreements in force, whether that's BITS, bilateral investment treaties, or other treaties that contain investment protections. There are actually more than 3,200 that have been negotiated, but only 26 of those are currently operative. 2,600 of those are operative. And that we have something like 1,100 known cases under those instruments, 740 of which approximately have been concluded. And all of that has come in about 15 to 20 years of real activity. That is, this is, you know, in a way, a new legal system that we are watching evolve before our eyes. We can't say at this stage that it's in its infancy, but I think of it as kind of being a teenager. And sometimes, like teenagers, they act out a little bit. They might misbehave. They might get a bit unruly, and that has prompted the stakeholders in the system to assess the system. Is it working the way they wanted it to, that they intended it to, that anybody thought it was going to? And those stakeholders most obviously are the states who created the treaties and created the instruments, but they're also the users of the system, the investors, the institutions that are involved in the proceedings, and stakeholders writ broad, civil society and citizens who watch the system unfold. And all of those stakeholders are assessing, they're reconsidering, do they need to calibrate? Do they need to renovate? Do they need to reform, or do they need to throw the whole system out with the bathwater? And that has been the discussion that has really come to life in the past few years, and that we're going to talk about today. And we're going to be, you know, that discussion has taken place in many forums. Whether that's UNCITRAL's Working Group 3, whether that's ICSID's reform of its arbitration rules, various initiatives at the IBA and at ICA and other fora as well. We're going to try to focus most specifically on the concrete proposals that are currently under discussion in many different formats, and that we're taking the liberty of going beyond the title of our program, because we will talk about the proposals for an investment court, for an appellate mechanism, but we'll also talk about other initiatives that are under discussion as well. Let me start out by doing some brief introductions of our wonderful panel. And I will try to keep them brief just in the interest of time, because if I actually gave fulsome introductions of everybody, we could be here for quite some time. But in approximately the order that we'll be speaking. So we begin with Anna Joubin-Brett, who's the Secretary of UNCITRAL and the Director of the Division of International Trade Law at the United Nations Office of Legal Affairs. She previously also worked in the Investor State and Investment Disputes Forum as counsel, as arbitrator, and as mediator. And also spent, I believe, a little bit more than 15 years at UNCTAD as senior legal advisor in the research program, overseeing the research program on international investment agreements. Then we have Colin Brown, who's from the European Commission, DG Trade. He's the head of unit of legal affairs and dispute settlement with focus on trade, sustainable development, and investment, in addition to serving in various capacities as a visiting professor. And I think of Colin as the person who has spent the most time explaining the investment court proposal to the world in forums like this one. We've had the pleasure of being on some other panels together as well. Then we're joined by Margie Jaime from the Republic of Panama, who's advisor and chief of the Office of Compliance and Liabilities in the Ministry of Economy and Finance for the Republic of Panama. Prior to her previous position, or perhaps concurrently, I'm not sure, she's also a professor of law at the University of Panama and has worked in private practice, and then had a previous life as a trade negotiator for Panama as well at the Ministry of Trade and Industries. Then we have Chiara Giorgetti, who's the professor at the University of Richmond School of Law, where she teaches public international law, international arbitration, international courts and tribunals, and is very active in all of the professional associations surrounding international law and international arbitration, including the American Society of International Law, the International Law Association, the Institute on Transnational Arbitration, and also had a prior life in private practice, practicing in international arbitration in both Washington and Geneva, and has been especially active in fomenting the discussions about codes of conduct and codes of ethics for the participants in this system. And last but certainly not least, we're joined by Karen Kaiser, who's an attorney advisor at the U.S. Department of State, currently in the Office on Private Investment Law, Private International Law, in which capacity she's representing the United States at the UNCITRAL Working Group 3 discussions, at the Hague Conference on Private International Law, and at UNCITRAL as well. And previously also at the State Department, she advised on the negotiation and implementation of bilateral investment treaties, and also served a stint as counsel in those cases at ICSID. I, of course, should start off with the caveat that every single one of our speakers is speaking in their individual and personal capacity. Nothing they say is for attribution to their employers or anyone else that they might be affiliated with. But we want this to be a really fulsome discussion. The way that we'll proceed is we'll ask Anna to sort of set the stage for really kind of a background of what's actually actively happening in the reform discussions surrounding ISDS. And then we'll start picking up some of the individual proposals. So we'll ask Colin to give us some background and bring us up to speed on the proposal for an investment court. Margie has done some thinking about what's been presented as an alternative to that as an appellate mechanism. So we'll ask her to talk about that. Chiara will help us frame the discussion on the code of conduct that's been presented as a full draft code of conduct. And Karen's going to fill us in on some of the other reform initiatives and proposals that are also active at this time, even if they're not grabbing as many headlines as some of the other initiatives. With each of those, we'll ask, as I said, Anna will set the stage for us for sort of 5 or 10 minutes. And then as we go into the individual subject areas, we'll have one of our speakers kind of give a 3 or 5 minute explanation of the current state of play. But then we really want to invite all of our other panelists to chime in and comment on what's happening in that space and where they see the discussion going. So the idea is sort of, brief presentation, comments, and so on and so forth. We'll be keeping an eye on the chat for questions from the audience. We might try to take some of those as we go on the different topics, or we may save some of them up for the end. So bear with us as we proceed fluidly through this process, but we want it to be as dynamic as possible. So I have done more than enough talking, and I'm going to turn the stage over to Anna, please, to help us with a bit of background and understanding of what's happening in the reform discussions.
Thank you very much. Thank you, Marin. Thank you, Jose Antonio, Maria Lucia, and all of the organizers for having me. I was with you last year, and I'm very glad to see that this very valuable initiative is continuing to grow. And I'm always very pleased to join in and to give you an update of what we're doing currently in UNCITRAL's Working Group 3. So what I'd like to just start is it's sort of an update for you, because I already mentioned a number of these different elements of reform last year. But I'm very pleased to say that a lot has happened in spite of having to scramble with difficult meeting conditions at very odd hours across the globe, and with limited conference time. The working group managed to move along quite a number of these reform elements, and it did so, and we are on these different reform elements in different stages. So you might have seen last year already this little house that I like to show, because I think it gives you an impression of coherence in what we're doing. And I hope that will convey that it's a coherent effort, that all the member states, the observer states, the NGOs, the IGOs, the academic forum, the practitioners group are contributing to in the UNCITRAL context. So when I'm saying where we are working on building a number of the building blocks of the little house. And we have, for example, advanced quite a lot on the first little piece of building on the left, which is the development of investor-state mediation to strengthen access to mediation, to make it a more conducive possibility for disputing parties. For the time being, the treaties are almost, a majority of the treaties is silent about the possibility to go for mediation. The ones that are proposing mediation do so in a very limited time frame, for example, in only during the cooling off period. And it's only with very recent treaties that we've seen mediation taking its actual role in as a credible alternative. So this is being this has advanced quite a lot. We had an intersessional meeting hosted by China, by the Hong Kong SAR, only I think 3 weeks ago. And during this session, we managed to have a very good discussion about the different ways of fostering more mediation in investor-state dispute settlement. Another area where we have also advanced quite a lot is on the development of an advisory center, patterned along the lines of the advisory center that has been working quite effectively in the WTO. And there we have already had several meetings of the working group discussing the advisory center. And we're now at the stage of discussing text, which would focus the advisory center on its scope, on its membership, on how to finance it. We have also a very comprehensive study of the various ways and means to set up such an advisory center. So where we have also advanced is on the discussions of what I call the second floor of the little house, which is the appellate mechanism. And here you will hear more from Margie about where we stand currently. And here again, we have started drafting text for the working group. There's still a lot to be done, but
we seem to be losing Anna's connection, but I'm going to hope that she comes back because I want to hear what goes on top of the house. All right, we're going to hope that Anna returns with us quickly. But in the interest of not losing any time, maybe we should move on. Colin, why don't you pick up and share with us sort of the third building block from the left, the EU's proposal for the investment court, and how that's going to potentially build up to the second story of the house.
Yeah, thank you. I'm happy to take this up. I can keep on going as long as Suchu and we can see when Anna comes back. So let me also start by thanking the organisers for having invited me here. I would much prefer to be physically in Washington meeting you all, but we have to do with things as they are. Anna just texted me and says she's having a problem reconnecting.
Okay, well, we will try to get her in, but let's forge ahead,
okay.
And then we can circle back. She'll have
okay.
some interesting thoughts to share.
So I feel a bit like I feel rather awkward here because I'm coming to Washington Arbitration Week. And the main point that I want to make is that arbitration is not a very good idea for investment dispute settlement. So you can throw virtual rotten vegetables at me if you want. In that sense, it's probably safer to do this virtually rather than in person. But I think it's important to start with that point, because I think what we're seeing, and you can see it on the screen with Anna's slide, is we are thinking about how the system should be designed for the future. I think, Marion, you put it very well, that it's maybe in its teenage years, not quite sure where it's going, the direction that it wants to take, and it's a moment of thinking and consolidation. And I think it's important to look back in that context and think about how the system was created. In many senses, the birth of the system is an odd birth, in the sense that the dispute settlement system was developed principally through the ICSID Convention, historically through the ICSID Convention, without a clear idea of the nature of the regime to which it would apply. It was foreseen, of course, that it would apply to investment contracts, investment laws, investment treaties, but I don't think anybody in the 1960s, when it was developed, envisaged that it could be applying to 3,000 odd treaties. So I think one of the things that we have to think about, and this is one of the points that the European Union and its member states make in UNCITRAL, is, when we look at the system today as a maturing system, would we still choose this system of dispute settlement? And we think that the answer to that should be no, because we think the system is inherently one which is, if you want, a public law one, or a constitutional law system, because it is judging public actions. So in each case, it is a public action which is subject to dispute. It is the dispute served to fix a line between what the state can do and what requires compensation to a particular individual. It's unidirectional in the sense that it is typically always an investor, an individual, bringing action against the state. And it has a repeat function in the sense that the treaties are established, they're in principle in place for a considerable period of time. And because there can be repeat litigation, the questions of consistency and predictability, which come up frequently in the working group, are extremely important. I think one of the points that the European Union's member states make, and other supporters of a permanent mechanism make, is that when you look around the world at comparable types of systems, judging public law matters or judging constitutional law matters, you see that societies or systems are consistently revert to permanent bodies. We can see that in our domestic courts, or domestic administrative, constitutional, public law courts, and we can see that in international or regional courts that deal with, for example, human rights matters. And we think there are powerful reasons for that. We think the primary one is that permanent bodies deliver consistency and predictability. And I think a good example of this, currently not in a particularly good shape, but a good example of this is the WTO appellate body, where there was a lot of criticism of the WTO in the 1980s and the 1990s about whether it was getting the balance right in that moment in time. It was between free trade and the protection of the environment. And the creators of the WTO did not change the substantive law. What they did is they changed the adjudicatory system and created a permanent mechanism in the appellate body. And these concerns have over time dissipated because the appellate body has developed a particular approach on the balance between, for example, free trade and environmental concerns. So in our view, this move to create a permanent court brings about that consistency and predictability. With all due respect to Margie's position, it doesn't, in our view, an appellate mechanism is a helpful part of that, but is not enough in and of itself to bring about that consistency and predictability. But we think it also has the advantage that it reduces costs, which is another one of the big issues that comes up in the working group, because of the consistency and predictability. So actors are better able to decide whether to bring a case. Respondents are better able to decide whether to litigate something out or whether to settle. And we think it also has an advantage that it is a more effective, provides more effective resolution of some of the ethical issues which come up, and which Chiara, I'm sure we'll talk about in a few minutes. Now, how do we see this? What are the concrete building blocks? These are being put in place as we speak. There is the next meeting of the working group in February is slated to discuss these matters, and there are texts which are available looking into these issues. From our perspective, a permanent mechanism, a court, would need to have full-time adjudicators that are appointed on long-term, non-renewable basis to ensure they are independent. For us, it's extremely important that there be a mechanism to screen the suitability of candidates to be appointed to the permanent mechanism, and there's text on that particular matter, which is before the working group. And we think that it's also important that there be an appeal mechanism. So on Anna's presentation, which is still on the screen, we think the two parts go together, a permanent court and an appeal. And for us, it's also extremely important, and I think this is also a big part of the agenda, that we have mechanisms that can ensure that these reforms permit their application to all existing treaties. And so we foresee and we envisage an opt-in approach that would allow the application to existing treaties. So that's what I wanted to say. I don't know how concrete that was, but I think given the kind of issues before us, I think it's useful, at least for me, to start by coming in and explaining what is the impetus behind what we think would be an important shift from one system of dispute settlement to another. And I'll stop there and happy to engage in the discussion as we go forward. Thank you.
Thanks so much for setting the stage there, Colin. And I did just want to say thank you so much to Anna for coming back I think procedurally we'll forge ahead and spend some time talking about the investment court and the appellate mechanism and then the code of conduct, and then we'll come back and ask Anna to sort of finish out some of her thinking about the overall reform program, and then Karen will weigh in as well on some of those big picture issues. So let's take up this issue of the investment court. And Colin, I think it's admirable, if challenging, to say that you're modeling it on the WTO dispute resolution system, which is a system that's currently moribund. So is there a danger in a state-created system of state breakdown? Do we run those same kinds of risks that we see in the WTO system right now? Or are you already thinking about the preventive mechanisms?
So just to be clear, we don't model it as such on the WTO.
Understood. But you invoked it, so I'm gonna hold you to that.
That's fair enough. And we don't model it precisely on that. In part because, precisely as you say, we have collectively learned lessons about how international adjudicatory bodies should function. I think one of the advantages that Working Group 3 has, and the academic forum in particular can contribute to this, is we have had a slate of international courts in operation since the early mid-1990s. And we know lots of things that work, and we know also lots of things that don't work. Mm-hmm. And I won't get into the specifics of all of those different things, but I think one of the things that's incumbent on the working group is to actually precisely look and see, well, what are the practices that we would want to take up that are effective and that are useful. So one, if you look at the papers we've submitted, one thing is that we would not want to have unanimity voting for the appointment of adjudicators. At the same time, I think something that we also think has gone wrong in the WTO is there has not been an effective communication or exchange between the adjudicators and the legislators, if you want, the people that the negotiators, the states that have created the treaties. And we think there are good ideas on the table that start to address that. But I think one of the things that's coming out of UNCITRAL discussions is precisely you start to see some of these different things beginning to maybe meld is too positive and too strong a word at this moment in time, but you begin to start to see some of these ideas fusing and coming together. So there are lessons to be learned, not just from the WTO, but from a number of international organizations that that we can use when we think about how to structure a permanent mechanism.
Karen, do you want to chime in there?
Yes, thanks, Maren. And again, I'll just quickly echo that my thanks to the organizers for inviting me to the session, and I really appreciate the opportunity to participate. And in addition to your general disclaimer about these being my personal remarks, I should also note that the Biden-Harris administration is still formulating its positions in many international economic policy areas. So my comments are certainly without prejudice to any policy development. So they are genuinely personal observations. Now, that said, I think, as Colin has laid out sort of the case for a permanent institution, I think as we step back and look at or I think it's important for those who are participating in Working Group 3 to ask themselves really whether the case for a new permanent institution has been justified. And to date, it's not as clear that it has. I think it's important to keep in mind that when looking to establish a new institution, it's not taking place in a vacuum. It will come in, as you pointed out, to a framework or a landscape, if you will, where over 2,600 investment agreements have been interpreted, and we have 3 decades of practice. And it's important to sort of look at what's useful from that practice and what isn't, as opposed to completely just doing away with that practice. I think there may be certain, advantages about a permanent court, but at this point, those seem to be pretty much on paper in the investment context. We don't know how interpreting a variety of different agreements, which is not the situation that we have in the WTO context. I don't want to get into debating the WTO at this stage, so that's the last time I'll refer to use those three letters. But I think we have to keep in mind that there are certain advantages to the arbitration process, which is not something that states don't resort to at times as well. And I think there you have certain efficiencies of not having a standing body to have to upkeep. You have party autonomy and flexibility in terms of being able to establish tribunals when they're necessary. Because I think it's important to keep in mind that not all states are going to be sued on or are going to be involved in dispute settlement on a regular basis at the same basis. And as we can see, certain states have over time had more involvement in the process than others. And I think too, it's important to also keep in mind that these are very different types of instruments from the type of instruments that UNCITRAL typically looks at. So the working group is really kind of having to approach this in a different way and think about what its role is in terms of establishing something that would be permanent, and how the delegations would then perhaps stay engaged in a process were something to be included. And I think that raises some genuine concerns. And while Colin mentioned that there needs to be better relationship between the legislators and the tribunals, I think some of the rules that are being set up now that we're looking at don't go in the direction of supporting greater involvement, but they seem to be disassociating the relationship between the treaty parties and the decision makers, and not perhaps taking as great a providing for greater involvement, which one can do in a more targeted approach. And then I think finally, it's important that for a structural reform, I think one of the questions that still needs to be asked is how wide participation would need to be for it to be successful. I think something that ends up being more regional may not actually be viewed as being legitimate as a multilateral approach. And we have to be cognizant of the fact that we're at a juncture in investor state dispute settlement where states are, as you mentioned, recalibrating, reassessing their roles and making sovereign decisions in their own capacity on when and how investor state dispute settlement should be included. And I think the United States recent practice in the USMCA and Chapter 14 is a good example of that, where even within a particular agreement, you may have more discrete and differentiated approaches to how you address that. So I think ultimately it's important that while we may have a concrete proposal, that those proposals still need to be justified as we go forward in terms of thinking about reform. Thanks.
Thanks, Karen. Chiara, did you want to chime in there?
Yeah, thank you very much. It is. Thank you also for inviting me. I think it is really a pleasure to be here. I would like to give some comments and a little bit of a follow-up to both Karen and Colin, but I think it's a little, to my point, a little premature to really think about, like, say, pro or con, because we are really at the very early stage still. And so what I would like to offer is more comments, general comments. What I find quite interesting about this idea of the permanent court is that of all the reform proposal, this is probably the most far-reaching one, in the sense that it provides a systemic reform that would change ISDS, the ISDS system, really rather radically. And it also has the benefits of addressing a lot of the concerns that were identified as problematic on ISDS. So not only the issue of the selection and appointment of arbitrators and adjudicators, but also consistency, predictability of decisions, and time and cost. So it is really a measure that has a far-reaching aim. And what I think, so my two comments are what I think is very helpful to think about when I think about the court. Is that it is, yes, to think about the court, but it's not a kind of modeled on the International Court of Justice court. And I think this is quite helpful. So it's a permanent court, but I think for those of us who are familiar with ISDS, it's really something that is much more familiar as possibly, I don't want to talk about the WTO also because it has been already addressed, but if you think about the US-Iran tribunal model, I think that would be quite interesting because there we already know some basics of what we're looking for. So what the EU and others who want to think about the court are looking for. So we were thinking about a two-tiered model. So we have two instances, which I think are helpful in addressing a lot of the issues. We think about permanent judges also, and very specific jurisdiction, both personal and subject matter. And I think thinking about the possible court as in these familiar terms by ISDS is kind of more helpful. And also, I think it's quite interesting thinking about the building that Anna presented is part of a bigger project. So it's part of a. It doesn't need to be endorsed or adopted as a global court. It's more, I think, my understanding is more of an opt-in, and in that way, it's kind of all international adjudicatory systems you opt in, you know. But I think it's interesting to think about that also. That is one of the different systems that are offered as an ISDS reform. Thank you.
Anna, I'll give you the floor and then turn over to Margie, because I'm hoping that Margie can take her comments and then move us on to talking about the appellate mechanism. So Anna, something to share there?
Thank you very much, and apologies for having been kicked out. It took me a bit of time to re-emerge. So I just wanted to say that when I was presenting these different entry doors for investors, and also the, thanks for putting it up again. There are two things that I would like to flag. First of all, on top of the building is the state control. And that is something that I think is very broadly accepted in the working group, that what the states at least want to do is to regain control over their treaties and over the system that they have established. They are looking at it with different priorities, with different approaches, but they really want to regain the control over the treaties of which they are the masters, whether we like it or not. And they have farmed out dispute settlement, they have farmed out interpretation, and all of this is now coming back on the table as reform elements to ensure that the states are not completely left out of the interpretation of their treaties, and that they have ways of correcting course when that is necessary. And the second point I wanted to make in this regard is that indeed and that's why I started with the two wings of the building, is that we are at different stages of development. And the Multilateral Investment Court proposal is because it's a complex reform element, because it touches upon many others, because it has a strong, of course, link to this appellate mechanism that is also favored by a number of states. We are really beginning, as Chiara was mentioning, to look into it in depth. And that's exactly what we're going to do in the coming sessions of the working group, including the next informal session that takes place in 1 week, or next week actually, where we're going to look into also the design aspects. And we will be discussing more on costs of establishing such a body, on text for establishing it, on linkages between the designation, selection of adjudicators and the mechanism themselves. So we are really getting into the hardcore of one of the strong and difficult elements of reform when we're looking into this court and into the appellate mechanism. So I'm glad that you selected them for a more in-depth discussion at that panel. Thank you.
Great. So, Margie, I held you off because, as I said, I wanted to get your comments on the permanent court idea, but then also you can take us into the appellate mechanism, which is sometimes presented as an alternative. Sometimes, as Colin mentioned, it's sort of part of the investment court discussion, and so I hope you'll take us there.
Thank you, Marin. And well, before starting with the discussion, so I would like to thank the organizers, especially Jose Antonio Rivas for the kind invitation and putting together this panel, and of course of you, Marin, for the moderation and for mentioning at the beginning that all our comments are in our personal capacity. So I would like just to start, so when with what Colin was mentioning at the beginning, and the thing is that when the system was created, of course, it was not created for the myriad of investment agreements that we have right now. When the ICSID was established, so there was just a few investment agreements, and it was created for contractual disputes more than for investment disputes. So the annulment proceedings that we have right now, it was good for that system that when it was created, but right now the reality is that it doesn't adjust to the reality that we have right now with almost 3,000 of investment agreements in force. So that is, my first general comment. Second, I would like to just refer to a few issues and compare the appellate mechanism with the Multilateral Investment Court, because Colin also mentioned that the appellate mechanism will not solve everything, and that and because of that, the standing body will be preferable than just having an appellate mechanism. But first, I would suggest that the establishment of an appeal mechanism does not raise the same concerns as the permanent investment court would do regarding the selection and the appointment of the decision makers, as parties to the dispute may continue to appoint the decision makers of the first instance tribunal. And in fact, parties do not make appointments at the review level, right? So in the set aside of arbitrary tribunals, of arbitral awards, is decided by judges at the seat of the arbitration. And likewise, members of the ad hoc committees under the ICSID system are appointed from a roster of arbitrators by the chairman of the administrative council. So that will make a big difference, because in the if we have only an appellate mechanism, then parties will continue to have the rights to appoint the decision makers at the first instance. Second, it has been said that it could be problematic to operate remand, because the ad hoc first instance tribunals, they will end to exist. However, unlike in domestic context, where the remand of the issue to lower instance is the rule, an appeal tribunal in the arbitration context should be able to modify or reverse the legal findings and conclusions of the first tribunal without the need to remand the issue to the new tribunal. So we could argue that that problem could be solved with having just an appeal mechanism and not. So with that, it won't make a big difference if we have, the whole first instance and second tribunal as a permanent standing body. So in that sense, an appeal mechanism will avoid the resubmission of the dispute to a new tribunal whenever the tribunal award has been set aside or annulled. And an appeal mechanism, as I mentioned, it would allow the parties to continue selecting the decision makers at the first level. And at the same time, it will set a higher level of continuity in the composition of adjudicators at a second level, which is, in our view, a key element to achieve consistency and predictability, because the appeal mechanism is conceived to create coherence and consistency in the ISDS system. So this is a clear advantage of an hybrid procedure with an ad hoc first instance tribunal, preserving the party appointment principle, and an appeal mechanism for treaty-based arbitration, regardless of the institution or arbitration rules under which the arbitration is conducted. And third, and I'm glad that Anna mentioned the cost of the procedures, because this is also another element that is of concerns of state parties. So how much it would cost, right? So an appeal mechanism with a standard or quasi-standing body will also present several advantages, in our view, compared to a multilateral investment court regarding the cost of the procedures. In the case of a permanent investment court, it is uncertain how dispute settlement proceedings will be funded and maintained over time. While it is true that financing contributions could be made by contracting parties in accordance with the respective levels of development, it could present a heavy burden on public finances for some developing countries. So you have not only the salaries of the adjudicators, but also you have to think on how to fund, so to have a secretariat. And the other problem with that is how can you match this system with the current system, with the ICSID or the other, let's say under the UNCITRAL arbitration rules. So that, in our view, could present several inconveniences from the cost perspective. So I don't know. Well, the other thing is we will have to think in how long or how long will be the period of those adjudicators, right? And if we think on that, we could think also on the pool of arbitrators that we will have, because the terms depend. Perhaps we will be closing too much the pool of arbitrators to decide the cases. So with that, I think I would finish my initial comments, and I'm looking forward to hear from others. Thank you.
Thank you, Margie. Thank you so much. Colin, I gave you the unfair setup of letting you explain the permanent investment court and then have to sit there while everyone else commented on it. So I'll give you first dibs on responding on the appellate mechanism, and of course you can pick up any of the prior discussion as well. And I will say that Colin was the one who warned me when we were planning this session that the hard part is going to be keeping us moving along. So we may not have time to let everybody comment on every proposal, but I'll let you at least start us off.
Yeah, so thank you very much, Maren. And I will try to be brief. Indeed, I think we could talk about this until the cows come home, as they say. I think maybe just a couple of comments on the appellate body idea, and then maybe a couple more general comments, picking up also a couple of the points that are made in the chat. So, as I've said, we view an appeal body as being something which is important because it provides consistency, provides clarity, provides continuity, and it provides finality, which we think is extremely important. I think we would be concerned that a non-permanent first instance would kind of lead to continued complications, because you still have the problems of ethics, the problem of double hatting that we were struggling with in the working group a couple of weeks ago would remain an important issue. You still would have problems of cost. There's I recommend this frequently. There's a very good video from Professor Philippe Sands, which is available at the Columbia Center for Sustainable Investment Law, I think, talking about his experiences as an arbitrator, and he explains the impacts on costs. And I think the other thing that we see is that I think the experience is clear that there are issues that cannot be, where remand is necessary, issues that cannot be completed on appeal. and remanding evidently in the existing system is complicated. But we also think a bit more fundamentally that there will be issues if you create an appellate body. There will be issues of continuation of the ad hoc system, whether the ad hoc tribunals will follow or not what the appellate body has said. And that, we think, is likely to actually lead to more litigation, more cost, than if you have a permanent first instance relating directly to an appeal mechanism. And I think maybe, and this I would say a bit more generally, we do have to, of course, think about the system as it stands today, and we have to be careful in terms of the advantages and the disadvantages. But we also have to think, and I think this is really the challenge for the working group, I think we also have to think about how do we deal with this system in the long term. If we are teenagers preparing for, or we're looking at it as a teenager preparing for adult life, and Karen and I have teenagers about almost the same age, thinking about these things, then you really are trying to think of, well, what is the base that allows this system to grow into a stable adult that can make sure that that this functions well. And we are not convinced, and I think this is really the problem, we are not convinced that the areas which were identified as being problematic in the working group can be solved without moving to a permanent body, because you still have the ethics concerns, you still have the consistency, predictability concerns, you still have the time and cost concerns, and it's only really by making this change that you move across. Now, like every new system, it will take time. Like every new system, it's easy to say, well, we don't know what it looks like yet. And Chiara's perfectly right. We need to start to look at what it looks like before we can make a judgment call. But I wanted to also specifically to pick up the point that both Karen has made and Elsa, an old friend of mine, in the chat about the existence of there being many treaties compared to the WTO, where there is one treaty. Now, we think that problem is one that is exaggerated, because if you look at the treaties, these treaties have a great deal of commonality across them. So knowing how an MFN clause is going to be interpreted, having a permanent mechanism and an appeal mechanism, developing a consistent interpretation, for example, of MFN or national treatment or fair and equitable treatment, will provide guidance for a large number of treaties. And it is also something which is quite common that, and think about this from our domestic systems, think about this even in arbitration, that we accept that adjudicators deal with different sources of law and can make distinctions and can construe them in the way that the negotiators intended them. So, I think from our perspective, the fact that there are a large number of treaties, rather than being an argument against a multilateral mechanism, actually an argument in favor of it, because there is such similarity, often identity, across the treaties. But I'll stop there because we're already, as I warned, we're already taking a lot of time. Thanks, Sarah.
No, but thank you for that, Colin. I think that's really helpful. Let me let Karen chime in, and then I'll ask Chiara to come in and pick up what's been put out there as one of the possible solutions for those ethical issues that Colin was alluding to, and tell us more about the code of conduct. But Karen, first, why don't you take a minute or two to react?
Thanks, Maren. And I will be very brief. I think Margie set out, I think, the key issues that need to be looked at when we're looking at an appellate. And I will leave many of Colin's points unresponded to only because we have a lack of time, not because of any commonality on some of them. But I think one of the key issues, and I will pick up on this from Colin's point about many treaties, is that we really have to grapple with what do we mean by consistency and predictability. I mean, I think correctness of interpretation is important, but when we get into the question of consistency, we don't want consistent decisions that are not consistent with the meaning, the understanding of the treaty parties themselves. And so I think that's an important safeguard that we have to work in. I think we have to think about how consistency is would be, if that is truly a goal, how that really works if it doesn't have precedent. And if there is precedent, that seems to be introduce a very different approach to international law and these types of disputes. And I think there really still needs to be some grappling with what are considered justifiable inconsistencies in decisions that have been coming out of ad hoc arbitration tribunals, because even in domestic law, we have courts that may take a different gloss on something, and that doesn't necessarily mean that it's that we have inconsistent outcomes. And so I think those are issues. I don't have an answer to it, but I think that's something that we need to also take into account when we're looking at this issue, just to add to the list of Margie's comprehensive list of things that we need to think about as well. Thanks.
Thanks so much, Karen. So, Chiara, I'll put it in your hands. Do you want to say a word or two on the appellate mechanism before you take us into the code of conduct, or would you like to launch directly?
I think I better launch directly, just because we can stay here. Of course, we can talk about the court, or we can talk about the appeal forever. But why don't we switch on? And if you have time, of course, I can present something. I can give my comments later. But I will be very happy to talk today now about the code, because differently from the presentations that we have just now, this is much more detailed and more focused. So it's kind of simpler, but I think is nonetheless very significant and will have a very significant impact on ISDS, both in terms of the procedure and substance of it, but also in how ISDS is perceived. So what I would like to do is to quickly give a very quick review of the proposed code of conduct, and then give an update of the recent negotiation. Of course, then we can discuss more. We are now at version 3 of the draft code. The first was released in May 2020. Of course, this is a common effort between ICSID and UNCITRAL. Was revised in April and then in September 2021 again, taking account of all the comments that were received. The latest iteration, I think, is quite interesting because it gives very specific choices for delegates, which I think shows very much that the negotiation have entered a new phase and the commitment to this new code. The code has now 11 articles and 1 annex. It starts very briefly, Article 1, with the definition and application sections to whom would the code apply. The brief answer is only to adjudicators and possibly somehow candidates and assistants. It does not apply to counsel or mediators. And what kind of situation would be covered also by investment arbitration. So to whom would apply. Then it goes to the specific basic obligation, independence and impartiality, the issue of the duty of diligence, availability, the high standards of integrity that adjudicators have to show, fairness, competence. Talks about the prohibition of or regulates ex parte communication, issue of confidentiality, fees and expenses. And then 2 highlights. Article 4 addresses the issue of double etting, Article 10, disclosure. I think I would like to spend it very, very briefly just about disclosure, because disclosure is very much of the basic frame of the code. The code requires a broad disclosure to enhance transparency and determine if a conflict exists. Article 10 requires first a broad disclosure by adjudicators of all issues that may raise doubts as to the independence and impartiality of the adjudicators in the eyes of the parties, which I think is very important. Adjudicators must make reasonable effort to become aware of such interest, relations, and matter, and the obligation of disclosure is continuous. Article 10.2 then gives certain examples of necessary disclosures, for example, financial or business or professional relations that exist with certain participants in the process, or also cases in which the candidate or adjudicator sits or has sat going back a yet unspecified number of years, and to include also their role as counsel or expert. I think this is quite interesting, the issue of disclosure, because it's intended to be very, very broad and incorporate also issues that were required of the code, like repeat appointments, for example. Article 11 then looks at compliance, enforcement, and implementation included. So adjudicators must themselves comply with the code, and disqualification and removal procedures in the applicable rules and treaties also apply to adjudicators in the code. The questions are, what are possible alternative or additional sanctions, either financial or other kind of sanctions, and how to implement the code. Should it be by treaty, or should it be by agreement of the parties, or by agreement of the adjudicators? So how to apply the code. Some of these issues were actually addressed in the negotiation that occurred just before Thanksgiving. The UNCITRAL delegates met for 1 week, and negotiators were able to discuss some of the important issues, but in fact not all. Namely, so the issues of the definition of disclosure, the extent of disclosure, and the issue of compliance were not discussed. The preliminary issues took actually a long time, and I think it's actually a testament to how involved the parties are to make sure that the code is applied. So some of the issues were really preliminary and very important issues. So for example, I would like to talk about 3. One is we spent quite a bit of time talking about the scope of the application of the code and the definition of international investment dispute. In terms of the scope, what is the role of the assistants, what is the role of candidates, but also the relevancy of the provisions of the code to permanent judges. And so there were some discussions about whether we should have 1 or 2 codes. I think the agreement was that we should have 1 code, but where the specific provisions that apply to permanent judges will be significantly highlighted. Similarly, originally in terms of the definition of IID, International Investment Dispute, originally the code was going to apply to all investment cases, including treaty, contract, and laws. That changed in the second and third draft. I think that was another point of discussion. I think now there was an agreement that we should apply to as much as possible, including treaties, contracts, and domestic laws. A fair discussion also on Article 3, independence and impartiality, and especially on the issue of the discussion on the issue of kind of appearance of bias. So adjudicators are required to be independent and impartial, and a lot of discussions about how to build on this and whether and how appearance of bias should also be included. A fair amount of discussion, and this will be my last point, was also kind of had on the issue of double hatting. Article 4 provides for regulates double hatting as concurrent roles that adjudicators may or may not play. And it's quite interesting because Article 4 provided for 3 different options: a full prohibition, where the adjudicators could not concurrently act as counsel or expert in another IID case; a modified prohibition, so where the adjudicator cannot concurrently act as counsel or expert in similar cases, possibly with the same measures, same legal issues, same parties, same treaties, to be defined. And then a third option would be the full disclosure, requiring adjudicators to disclose or overlapping roles with options for challenges for lack of independence and impartiality. I would think this was probably one of the most significant debates. There was always, in these 3 options, there was always an option for parties to agree that adjudicators can serve anyhow. So most significant debates, a lot of discussions about this. My understanding from the comments and the discussion is that a lot of states want prohibition, not all, but there are concerns, significant concerns, especially by practitioners, that a prohibition, a complete prohibition may be overboard. I think that there was an understanding that possibly this option 2 of a modified prohibition might be the way forward, requiring, however, full disclosure by adjudicators of all of their possible different hats they were wearing. So I think the negotiations really push forward and put forward a lot of the understanding of the code, a huge advancement, I think, on the code itself and making it much closer. I think the code is one of the options that might be for presentation, really for presentation to for approval in 2022, and I think it's possible to have that. I'll stop here. Of course, we can talk about this for a long time, but I look forward to having discussion with the others. Thank you.
Great, thank you, Chiara. Before we sort of dive into using a few minutes to respond or to talk about the code, let me actually turn to Karen and just invite her to remind us of some of the other reform proposals and initiatives that are out there circulating as well, and then maybe we can all comment on them collectively or some of the different ones out there. But we've focused very much on the permanent court option, the appellate mechanism, the code of conduct, but there are other initiatives in play as well. So Karen, do you want to say a few words about that?
Sure, thanks, Maren. And I think just, in terms of concrete proposals, I think the code is an excellent example of where we have concrete text, we have a concrete proposal. The work between ICSID and UNCITRAL has really been quite excellent. And I think seeing how the working group has grappled with that, because this is a topic where there's been a lot of thought, there's been a lot of work, and we're able to kind of come to work on that, making a conclusion of the code a real reality, a real possibility by probability, I should say, by the end of by the Commission in 2022. And I think that there are other proposals out there that are elements where they are sort of ready-made, if you will, from existing agreements. For example, proposals to address concerns about frivolous claims or unmeritorious claims. There are provisions on trying to address security for costs, where states have been concerned about not being able to recover their costs. Provisions on regulating third-party funding. We have provisions that encourage greater involvement by the treaty parties. For example, when a treaty party is a non-disputing treaty party to a dispute and can share its views on how the interpretation of a particular provision should be or how particular provision should be interpreted. And similarly, joint commissions, which of course are, both of those measures have been very actively used by the 3 NAFTA parties. Those are reincorporated in the USMCA and in many agreements that the United States has been a party to, such as the U.S.-Panama investment chapter in the U.S.-Panama Free Trade Agreement and many others. Really important tools for interpreting or for framing interpretations and guiding that so that you can avoid some of the concerns about consistency that have been flagged. And I flagged those. Anna already mentioned the Alternative Dispute Resolution and Advisory Center. Those are obviously going reforms that are being looked at. But I think all of these can be looked at as concrete ways to address particular concerns more discreetly than trying to sort of think about having an entirely new system. And in fact, there are a lot of commonalities between what has been proposed as a permanent international court and what could be very specific reforms for the existing ad hoc system, to where we might look at these differences as really ones that go to how adjudicators are appointed as opposed to the mechanics of how the proceeding should go forward. So I think all of those types of proceedings, or all of those types of provisions that I listed, that we can draw from lots of examples in existing agreements and really can help remedy where I think a lot of the problems that we are currently dealing with have arisen, and that's been in so-called first generation older investment agreements that do not have a lot of these safeguards and have not been able to benefit from the evolution of experience and practice. And so I think one of the things that the working group, of course, will also be looking at is a practical way to implement the types of reforms. And I think implementation, is itself a very large topic, but I would simply say that there are multiple ways to do that. And I think the ICSID rules amendment process is one way to show how the arbitration rules themselves can be adjusted to address, to capture many of the concerns that have been identified as well. So I think we've got a lot of concrete examples that are not necessarily structural or systemic, but are very important and targeted to get at the problems that are being identified by the working group. And again, I think the code of conduct is an excellent example of how we can address concerns about ethics very in a more discreet way and improve upon the rules that we have out there right now, and building on the best practices from, say, the IBA guidelines or other tools that we have. And I will stop there because I think you're probably 1 minute until we have to move on to the breakout.
So I'm going to thank you so much, Karen. I'm going to give Anna the privilege, since she was starting us off and since the technology deprived her of the floor. I'm going to give her back the floor. For maybe, Anna, you could share with us a few comments about where you see this process going forward and how it's going to progress. In addition, if you wanted to respond to any of the prior interventions, but I'll give you the privilege of closing us out before we head off into our breakout sessions. And just a word for all of our participants, please stay around for the breakout sessions. It's a great time to continue the conversation, to get to know other people who are interested in these same issues, and to really engage. And I think everybody enjoys them. So please stick around for that as well. But so Anna, take us away.
Thank you very much. I just would like to dovetail on what Karen just mentioned, which is the delivery mechanism for all this reform, these different reform elements. And this is what we are also going to start looking into. We had a number of very solid proposals that were put forward to, of course, use the mechanism that UNCITRAL has used in the Transparency Convention, but you can also think about some precedent that the OECD has given in the context of the BEPS, the Double Tax Treaty network. And so this is next on our agenda for the informal sessions that will take place next week, where we will have 2 full days devoted to the delivery mechanism, which is, according to a number of proposals, going to be a multilateral convention with lots of flexibility inbuilt, and with the possibility of including different elements, some of them being sort of core elements that will apply to everybody, and others that will be more optional. And another thing I wanted to allude to is that from the beginning, it was very clear that we didn't have a closed list of reform options. Now that we are reaching the elements that we are now working on delivering, there are still issues that are at the option stage. And there we have been reminded quite strongly by developing countries, particularly from Africa, that there is a need to look into calculation of damages, which is a big issue according to a number of the states in the room. And there are also another set of what they call the cross-cutting issues that also need to be looked at more in detail. We're getting more and more as we are advancing, but you can rest assured that next year when we come back, if we are re-invited, and if I don't get kicked out before joining, we will have more to report and good progress, because the working group is extremely committed, as most of the speakers have said, and we're making good progress. It's slow because it involves states, and the time of states is slow, but it's steady, and that is very heartening. Thank you very much.
Thank you, Anna. I think that's a nice place to wrap us up as we look ahead to what we'll be hopefully discussing next year. I do know that there's so much more that we could all say about all of these different issues. because there is, just as the states like to talk about them all, so do we all as the participants and stakeholders in the system like to talk about these issues at length. And I'm sure that there are many drinks conversations to be had as well. So, but in the interest of sticking with the Washington Arbitration Week ethos of letting everybody participate and get to know each other as well, I don't want to lose out on the breakout sessions also. So I'm turning it back then to Jose Antonio to direct us accordingly. Thank you, Maureen. And in the order that I see you on my screen, thank you, Karen, Chiara, Margie, Colin, and Anna Joubin, and Brett, and of course you will be invited next year, no matter in what capacity you are. That goes without saying to you and to every member of this panel. It was an amazing panel. I still have questions, many, on the sort of more avant-garde themes like investors' rights and direct claims by states to investors. Those themes are, of course, much expected by the international community, and hopefully the discussions would move forward on that, given that many of the topics that are being discussed now have been, despite news, have been there for I would say for decades. So the appeals mechanism was something that was discussed at ICSID when I was counsel there in 2006. So talking about a court and an appeals mechanisms, although in appearance revolutionary, it's not that revolutionary. But in any event, I will not go into it because it's not my place to hold my opinions down. But I would welcome everyone to our breakout rooms. The mechanics of the breakout rooms, I shall say, is that you should be receiving an invitation to join the breakout room. If you do not accept that, you will remain on the main room. So I urge you to accept the invitation to go into the breakout room so that you can see the stars of the panel, which are, of course, the speakers here. So take it away, Maria Lucia, so that we can go into the breakout rooms. And Maureen, thank you for juggling a hot topic with amazing gloves. This has been a pleasure, and many thanks to all. So see you in the breakout.